if it is in the interest of the people, and if it supports government policy to move forward, which is what we
Yeah,
did. So
I don't think that is in dispute. I don't
I'm
think that is
sorry.
in dispute.
Yeah, I'm sorry. So let me finish.
Hello, viewers and listeners. We're happy that you can join us for this, the April 2nd edition of the Bubb Report. Now, on March 26, 2001, an accomplished Grenadian economist and a native of Gwarvin St. John, who was trained at the London School of Economics, passed away after a long and distinguished career in public service and international development work. After completing his academic training, he joined the staff of the World Bank in 1966 and later shifted to the International Monetary Fund, where he was responsible for designing and implementing structural adjustment programs for Latin American, African, and Caribbean countries. In 1988, he published a 100-plus page open letter of resignation to Michael Camdessos, who at the time was the managing director of the International Monetary Fund. The resignation letter was titled, quote, "Enough is enough," unquote. This letter sent shockwaves around the economic world, making front-page headlines in many countries, except for the United States. In fact, it did not get any mainstream media coverage in American media. It was, however, featured prominently by Naomi Klein in her book, The Shock Doctrine. Buddha was the first person to break the IMF's code of silence regarding international affairs by exposing extensive statistical fraud carried out by the fund in Trinidad and Tobago during a structural adjustment period between 1985 to 1987. Now, he stated in his letter that the IMF package for Trinidad and Tobago at the time was an example of how the organization worsened third world poverty. This program, he said, required the removal of government subsidies from basic food items, the removal of government subsidies from school books and uniforms, as well as the removal of government subsidies on life-saving medical drugs. The fund, he also said, wished to cut the public wage bill to lift import controls, which allowed for an influx of consumer good items from the global north, thereby undermining local production. He also said that in the global south, the removal of exchange controls, the demand of the removal of the exchange controls by the IMF, created an environment where a privileged few could legitimately drain the country of the very few remaining dregs of foreign reserves it has in its possession. Now you may say, why does Mr. Budo matter? In fact, Budo's resignation must cause the region to reflect on how it can diversify its current economic interests away from the global north dictates of institutions such as the IMF. As Jamaica demonstrated a few weeks ago, the region must look to emerging multilateral organizations such as the BRICS Plus Alliance. The global financial crisis that had erupted in the United States during 2008 battered the global economy. The disaster paved the way for a rethink on changes to the architecture of global governance. The fragile political and economic global situation triggered by the financial crisis led to the emergence of a regional power confederacy, particularly within the developing world. Consequently, the importance of Brazil, Russia, India, China, and South Africa within the global governance structure has gone up, in spite of the challenges of the Russia-Ukraine war. The steady emergence of BRICS in global politics has been mainly based on their excellent economic performances. This development on the economic front coincides also with increasing cooperation and coordination, as well as the formulation of common positions on global political issues. BRICS as a united entity is expected to shape global governance in the 21st century. the influence already demonstrated by these emerging economies will surely continue to redistribute the balance of power in international financial institutions in favor of developing nations. We wish to welcome our spotlight guest for this week's episode of the Bubb Report, the Attorney General of Grenada, who is also the Minister responsible for Labor and Legal Affairs and Consumer Affairs. Senator the Honorable Claudette Joseph will be one of the cadre of ministers piloting the data protection bill before the upper house of Parliament this week. And at this point, I wish to welcome Senator the Honorable Claudette Joseph. Senator Joseph, welcome to the Bubb Report. I believe this is your second appearance on the program since assuming office. And I give credit to you for still responding to our calls and still responding to our requests. I can't say the same for some of your other colleagues, and I would give credit where credit is due. So I give you your credit for still having open communication with us here on the Bubb Report. Welcome.
Thank you very much, Dr. Bob, and it's always a pleasure to be on the Bubb Report. I know that Grenadians at home and in the diaspora listen fervently to your program as you disseminate information and credible information at that. So on that score, I would like to say good morning to all of your viewers and listeners, wherever they may be, and on all your various platforms. You can always count on me to be open and transparent with the people, either in sharing information or doing the work for which they elected me.
All right. And I wish you can say the same to your other colleague ministers as well, those that we have been trying to reach, but they see our messages, but they don't respond to them. We are fair on the Bubb Report. We are balanced, but we are also firm. Okay, so
I would do some intervention, but I am sure any non-response that you would have encountered would not have been intentional at all on their part, and I'm sure they all would have very good reason. But
I
would convey your sentiment.
Well, and I'm sure they can hear this interaction as well. Now, Minister, before we get into the weeds with respect to the data protection bill, now, obviously, the data protection bill came into public discourse recently. But one of the things that came up around this bill was the idea that this bill was sitting there at the level of cabinet. And I'm curious, you're also the Minister of Legal Affairs. I'm curious, are there other pieces of draft legislation that are sitting on a shelf somewhere in the Ministry of Legal Affairs that are in the queue to go before Parliament? Are there any other bills that the public should expect that have been sitting there that have not necessarily been prioritized in your view that needs attention?
And the answer to that is yes. Mm-hmm. One of the things that I inherited when I became Attorney General and Minister, as in the case of all ministries, there was a transition report. All ministers received a transition report from their predecessor. Mm-hmm. And in the case of the Office of the Attorney General, that included outstanding legislation that the Attorney General and the Cabinet had been working on and intended to take to Parliament. And I would say that that is expected and normal when you have a government transition. So in most instances, it doesn't reflect negatively on my predecessors. Because legislation, there are a number of steps that must be taken before a bit of legislation is brought to the Parliament. And from framing of policy in consultation with the relevant stakeholders to confirming the policy, both at the community level and at the cabinet level, to cabinet again approving the draft legislation. All of that has to happen. And before the legislation is drafted and approved by the cabinet, there's a whole back and forth trading that takes place between the relevant line ministry, the stakeholders, whether they be internal or external, and the Office of the Attorney General. So while it is true that there was some legislation that I inherited, not in all cases that will reflect any kind of neglect or delay on the part of government.
Mhm. So
In
there is
the,
not a neglect. Go ahead. Yes.
yes, I was about to say, um, in the case of the data protection bill, though, I would say that there appears to have been some shelving of it for a while. I don't know why that occurred. I don't know if maybe government priorities at the time did not um, did not dictate that they deal with it as urgent, but it is a bit of legislation that work started on since 2011 under the previous NDC administration.
Hmm.
And it wasn't just an initiative of government, it was an OECS initiative. All of the Eastern Caribbean states embarked on a movement towards e government and embracing technology for greater efficiency in government services. And that required data protection legislation in all of the OECS member states and territories. And so the data protection bill that is now before the parliament is an OECS model already passed into law in Antigua and on the way in the other OECS countries. So we inherited the draft and we reviewed it together with the Information Communication Technology Department of the Ministry of Economic Development. And we went back and forth a bit before taking it back to cabinet. I say taking it back to cabinet because the previous cabinet did approve the bill in March 2022. I want to repeat that for listeners. The data protection bill is not new. It goes way back to 2011. In 2021, the former government again picked it up and did some more work on it. And the previous government, headed by the now leader of the opposition, approved the bill in cabinet in March 2022. When a bill is approved in cabinet, the next step is to take it to the parliament. The only thing that prevented the last government from taking the bill to the parliament was the elections. So this is what we inherited.
Well,
We
yes, correct, Madam Minister and Attorney General. You say it's approved at the cabinet level, but Parliament makes law. Cabinet does not make law. So
yes,
even if they approved it for future perusal to the legislative branch of government, the legislative branch of government still has to scrutinize that legislation.
absolutely. So
Yeah.
the only thing is, Kellon, in the last dispensation,
Hmm.
the cabinet and the lower house of the legislature were identical, literally identical, because remember there was no parliamentary opposition, save one who was himself elected on the ticket of the former administration. So, if it was approved in Parliament, what in our cabinet, a reasonable expectation, and it would be reasonable for me to say that it would have been approved at the Parliament level because they were the
Hmm.
same individuals with no opposition, right? So
Okay.
that's the point we are making. So
Okay,
when
so you agree then with the previous administration that they ought to have brought the bill to Parliament. There is no disagreement there on your part on that
Yes,
question.
yes.
Yeah.
Mhm.
Okay.
And they
All
said
right.
they said so. They said they do not oppose the bill, but they
Well,
criticized some of their own work, so to speak, by
correct.
saying there were
Now,
certain aspects that needed review
right.
and that. But we could get into that.
Of course, and we will be getting into that. Now, Senator, the bill only came into the public imagination through inquiries by local journalists in Grenada, at least two eagle-eyed journalists, as I would call them. And had these eagle-eyed journalists not really brought their concerns initially to lawyers, attorneys in Grenada, specifically the president of the Grenada Bar Association, that bill might have passed in Parliament without much public outcry and fanfare. Shouldn't you then be giving credit to the members of civil society for raising some of the concerns that are proposed in the bill, as opposed to the dismissive posture the administration took, which seemed to suggest that the concerns that citizens were raising were not genuine? You made that point at your last town hall as well. You called it misinformation. You said that these concerns were all political. But shouldn't you be then given credit for to the journalists and to the bar association for raising those concerns in the first place? This is what your administration has been calling for: a more participatory and a more democratic approach to doing things.
Right. So let me answer your question this way.
Yes. Mm-hmm.
When we inherited the bill, part of the information we inherited the bill suggested that there was consultation with relevant stakeholders on the bill already.
Mm-hmm.
And as I said to you, the next step, based on where the process was, because taking an idea from idea to policy to legislation is a process. And the information we inherited suggested that the bill, there was consultation already with relevant stakeholders. So we carried it to the next logical step based on where we inherited. It is the role not only of the media and civil society, but of all citizens to, as you say, be eagle-eyed and to spot and to keep government in check, keep the various arms of government in check by making inquiries and so on. But these inquiries, I must say, they must be well-founded. They must have basis, all right? And I can tell you, Kellon, when the inquiries were first raised, concerns were first raised, a journalist called me because, as you say, I have remained accessible. So I received a phone call from a journalist who expressed concern. What did I do when I got that phone call? I said, well, as far as I am aware, we've looked at the bill. Our cabinet had gone ahead and approved it again because this was a new cabinet. So I took it back to our cabinet for approval in preparation for Parliament. We had approved it. But if you say there are concerns, none of us are perfect. So let me have a look again. I looked again together with the lead expert legislative drafter on the bill within the AG's chambers. There were a few things, for example, Section 39(2). I suggested to her that perhaps we can delete that section. This is all before the bill went to Parliament. And a few other minor things, but the main thing was Section 39(2). And we took it, we made the changes as suggested, and we took it to the House. And in the House, at the committee stage, by this time, a whole lot had been said. Some further changes were made. And I'll be frank with you, the changes that were made in the House were not necessary. They were not necessary. They were made in the spirit of compromise and so that we might show transparency and that we are not intending to pull anything on anyone. In fact, the object of the bill is to enhance the constitutionally guaranteed right to privacy, taken into account.
I get, yes, and we actually will be getting to that. But you said the bill went into committee stage, but the
Yes.
bill would not have gone into committee stage had it not been the advocacy of the opposition. In
No,
fact, the opposition advocated for.
All bills go to committee stage. All bills go to committee stage, and the purpose of committee stage is to examine the bill before the House,
Clause by clause, yes.
by clause, so as to make changes when necessary. And what I'm saying to you is that the changes that were made at the committee stage, and we can go through the changes that were made at the committee stage,
Yes.
right? We had, for example, Section 33. That's the one dealing with the arrest warrant. And part of that section says that an authorized officer who is going to execute a warrant issued by a magistrate may require any person on the premises to give information. And the word require there seemed to have troubled the very people who inserted the word in the draft in the first place. And so, in the spirit of compromise, and to show that we are not intending on trampling on anybody's rights, we change required to ask. But it really doesn't change the spirit and intent of the section. It's
But
all.
but even in that section 33 there, in
Mhm.
respect of that authorized officer, Dr. Francis Alexis QC, well, KC now, I have to make sure I get the title right. Dr. Francis Alexis KC, on his appearance on the Bubb Report 2 weeks ago, he expressed concerns that that authorized officer would be given too much broad powers in respect of their role on that commission. It's sort of a very arbitrary powers that these authorized officers can get before going to the court for a warrant in determining who that person is that they need to get a warrant for. So that part of the legislation didn't change. But
So
you're
let me
saying
tell you, let me
yes. Go
answer.
ahead.
So I did hear Dr. Alexis say towards the end of the presentation, and he's quite correct in that closing statement that he made,
Mhm.
that sitting where he sat then, he could not see anything in the bill that would cause him to think that the provisions of the bill might be weaponized or politicized to the detriment of the people, words to that effect, or used as a weapon or politicized against the people. And that is absolutely correct. That was his conclusion overall on the bill. Now, in relation to the specific section on the authorized officer,
Mhm.
one of the things the president of the Bar Association said when he appeared on another program is that there are no regulations yet. And that is correct. And the process we are following here with this bill is identical to any process in relation to a law that would require regulations to support it. And in the case of the data protection bill, a lot of the constraints, the restrictions, the parameters in which the authorized officer would operate, the the qualifications that an authorized officer should have. All of these things will be contained in the regulations to the bill when those regulations come. So, if you want to further understand what I'm saying, you might
Mhm.
want to have a look at the Data Protection Act 2020 of Jamaica, where you have very similar provisions. In fact, in Jamaica, the commission, one commissioner, it's one person that decides, whereas in ours it's three, right? Which gives greater protection to the citizen. One commissioner, and the powers of the commissioner they are very much broader, and the authorized agent, you have to go to their regulations to get the details that Dr. Alexis was referring to. And with the greatest of respect to him, I think that little detail, that little nuance, should have been explained by him and the president, because the president made the point that there are no regulations yet. But what he didn't say is that this is quite normal, because when you pass in a law, the first thing you do is that you pass the act in parliament. And sometimes, not all the time, sometimes you need regulations to fully bring the provisions of the law into force. And those regulations will come subsequent. Now, when an act is passed in Parliament, in the upper and the lower house, it becomes the law of the land, but it is not in force until a certain event happens, a publication of a commencement date in the Gazette, for example. So until that event happens, it is not a law in force. And normally, if a law requires regulations to support it, that commencement date will be postponed until the regulations are ready and available to be gazetted. So I am saying all of this to say to you, Kelon, and your listeners that there's a lot of noise around the data protection bill that, in my respectful view, is not warranted.
I was one of those making noise. I mean, and it's simply because I was concerned about that specific section 33. And I think some of those noises you say, with respect to you, you're saying it's not warranted. But I believe some of those noises were warranted. But, we can agree to disagree on that. But let us talk about the amendments. Now, one of the amendments in respect of the appointment of the commissioner speaks to
Right.
requiring the governor general to work in tandem with the prime minister, on the advice of the prime minister, in consultation with the leader of the opposition, to appoint the commissioners. Is it going to be the chair of the commission? Is it going to be all of the commissioners?
Right. So you're speaking here to Section 24.
Section 24, establishment of
Right.
the Information Commission.
Right. So it's the establishment of the Information Commission. Now, the original draft of that bill allowed for the minister. And under the Act, the minister is the minister with responsibility for information communication technology.
Mm-hmm.
Now, the original draft is the norm. Very normal to have the line minister to have to perform these functions in these types of legislation, right? Very few bits of legislation you will have the GG. So you're talking about the Integrity Commission, the Public Service Commission, other such high level and constitutional commissions. In countries where you have the electoral commissions, you would have the GG doing that. So this amendment that we made to section 24.2 of the legislation at the committee stage in Parliament, again, was another compromise, which wasn't necessary, but which I would say strengthened the bill and perhaps appeased people who have concerns somewhat. So it now, as opposed to the minister, the Governor General appoints the three-man commission on the recommendation of the Prime Minister in consultation with the leader of the opposition. And speaking here, I can think of no other bit of legislation where the Prime Minister recommends to the GG in consultation with the leader of the opposition. So that might well be a first in Grenada.
Why not take that further and have consultation with civil society as well? I mean, the leader of the opposition only represents the interest of one group of Grenadians, if you think about it.
No, the leader of the opposition represents the interest of a group that includes civil society. He represents, between the leader of the opposition and the prime minister, they represent all of the people of Grenada.
Okay.
So that would not have been necessary, really. And so if you go to section 24.3, the Governor General is the one who appoints the chairman from the membership of the committee. So it's a Governor General.
On the advice of the Prime Minister.
Normally, yes, on the advice. The only time the Governor General does not take the advice of the Prime Minister is where the statute says in his own deliberate judgment.
Mm-hmm. Yeah.
So here it's on the advice of the Prime Minister.
Mm-hmm. And that is section 33, of course, warrant to enter and search. As we know in our system, the courts is who decides on a warrant. We know that, and that there has to be probable cause. We know that in respect of how our system works. So you go to court. It doesn't necessarily mean that the judge would agree with the wanting a warrant. It has to be justifiable. So I think people need to understand that as well. So perhaps that's what the noise you were talking about. But you just can't go to somebody's house. Yes,
there is no difference here. Mm-hmm. This bill recognizes that. That is why it requires the commission or the authorized person to make an application on oath to a magistrate. And the reason why it's on oath, you have to give evidence in affidavit form on oath that will satisfy the magistrate that there is good and reasonable grounds to issue a warrant. And if the magistrate is not so satisfied, the warrant will not be issued. All right. And I want to make the point as well that in our ordinary criminal procedure code, I think it's either section 16 or 17, there's a section that deals with the power of the court to issue warrants of arrest, search, and seizure, and so. And if you go to that section, it's way more intrusive in terms of the powers of the police and so in issuing, in obtaining and issuing and executing a warrant than this here. Remember, this section here only allows the magistrate to issue a warrant of search and seizure on a data user. A data user is specifically defined in the legislation as a public body, so you're talking statutory and state-owned enterprises, or a private entity, so you're talking businesses and so, who receive personal data, personal information from the citizen in the course of conducting business. So it's not third parties, it's not journalists. I saw some concerns expressed somewhere that perhaps it might intrude on a journalist's right to acquire and disseminate or gather and disseminate information. Nothing like that, because the act only applies to data users as defined by it. Nobody else. Anybody.
What about political activists who might, in the exercise of public interest, happen upon information that might be of the public interest, who have access to that information? Shouldn't they not be concerned?
About what should they be concerned about?
Well, about having access to information that might be in the public interest, that the commission might say, well, actually, this information is not necessarily in the public interest. How did you get that information?
Right. So the commission will not have jurisdiction over such third parties.
Okay.
The commission only has jurisdiction over public and private bodies. So private bodies meaning like the financial institutions, the banks, the credit unions, your lawyer, your doctor, people like that in private business to whom you go to do business, and in the course of business you have to give this information. So if it happens that a third party comes by the information, that third party will not be subject to the sanctions of the legislation. If a data user, so one of these private entities or a public body, a government department or so, gives that information to the third party outside of the ambit of the legislation, then it is the person who gives the information that can be sanctioned under the act, not the third party.
So the person who gives that information, say that person gives information to me as a journalist. Mm-hmm. Although I think in Grenada there is not a journalistic registry in the way that lawyers are properly registered. So I think even in the context of defining a journalist, that is very open-ended to me. And but I'm saying that can be a loophole there that can also be exploited. Again, I'm a layman. I'm not a lawyer. You are the expert here. That's why you came here. But yeah, go ahead.
The loophole, I'm trying to understand the loophole you're concerned about. Because
yes, you said it would exclude journalists. Mm-hmm. Who do you define as a journalist? Do you define as a journalist someone who works with a particular media establishment, or do you also define a journalist as someone who calls themselves a self-declared journalist, for example? Because someone can get up in the morning and say that they're a journalist.
Especially in a Grenadian context, Kelowna, I'll be very honest with you, I wouldn't want to venture into defining what a journalist is. Right. What I want to make clear to assist in quelling some of the concerns that I hear is that the Information Commission will have no jurisdiction over journalists in Grenada or media workers. The Information Commission under the Act will only have jurisdiction over public bodies and private bodies to whom personal unique information is given directly by an individual in the course of doing business.
Mhm.
So, passport office, immigration, the banks, the electoral office, the entities, the public departments, and so that you share personal data with, so that you can get your business done.
Okay.
They
Okay.
are the ones who will be subject to the
So,
commission.
so the third parties, in other words, in essence, what you're saying to me is the sender of the information, the person who transmits information, who are defined either as private bodies in the context of people who work in the private sector,
Data
public
you.
bodies in the data users. Sorry, yes,
Mhm.
data users. You are correct. These data users, whether in the private or public sector, who transmits information to third parties. The third parties would not be liable, but the people who are
No,
responsible
that's
for
correct.
transmitting that
That's
information would be
that's correct.
liable.
Any sanction to be imposed would be on the data user because they're the ones who
Okay.
are subject to it.
So so the burden would be on the data user now, again,
Now
at,
you
at that level of
now
the
you
court.
get it.
Okay. I
Yes.
see. Okay.
Mhm.
That was and thank you for that education.
Yes.
I'm not a
My
lawyer,
my
but
pleasure. My pleasure. I anytime.
yes. Now, let us also talk about Section 45. Now, Section
Oh,
45 says, and I noticed there were no amendments there, but it said no criminal or civil proceedings shall lie against the commissioner or against a person acting on behalf or under the direction of commission or anything done for rather anything done, reported or said in good faith. Now, to me,
mhm.
good faith seems to be very open ended there. But that aside, um, how does that square up against uh, the responsibility or the obligation for due process rights in our system? So that section is saying, and again, perhaps as a layman, I do not understand in the way that particular legislation is written or has been written on similar commissions in the past. But the way I read this is, uh, if I want to countersue the commission as a data user, I may not be able to do so, even though the courts does grant me the due process right to appeal.
No, if a commission, no, there's a standard principle of law
Mhm.
that says that decisions of all public bodies are generally susceptible to review by the courts. So that if a public body or a government appointed agency or entity like the commission would be
Mhm.
does something that breaches the principles of natural justice, that breaches the constitutional rights, and because they would be acting on behalf of the state, that breaches the constitutional rights of the citizens. These acts can be challenged in the court, and the court has the power to review the actions of the public entity and offer redress. All right,
Mhm.
and that principle of law will not change. It lies all the time. This section 45 here is usually standard in these types of legislation. You will find it in many bits of legislation throughout Grenada, where persons who are asked to act in public offices, right? Things like planning and development authority, now also and so. I'm sure if you go through those laws, you will see that kind of protection being offered to members of boards of statutory bodies and commissions. I'm sure it's in the Integrity Commission legislation and so on. Once you are acting in good faith in the execution of your duties, so that once you are taking an action that, in your view, is in the best interests of the task of the people and the task with which you are charged.
Mhm.
Once you are taking a step that you think genuinely is in furtherance of the undertakings that you are required to undertake under the statute, you will be protected. You will be protected from criminal liability and civil liability. That's standard. There's nothing strange or untoward about that
Okay.
section.
But
If
but
they
but
go
the
out of
state,
the scope
go
of the
ahead.
authority, if they go out of the scope of the authority, if there is an unreasonable exercise of a discretion given by the act, and a citizen is harmed, there's injury done to the citizen because somebody went on a frolic of their own, or they acted outside of what the law permitted them to do, or they were given a discretion in the law and they abused that. These matters will remain subject to review by the court.
Mhm. Okay.
So
But
that's what.
but that does not give the state immunity from litigation. I mean,
No, it does
the
not.
unions sued the state and won on the
Yeah, it does
pension
not.
matter. So
It does
okay,
not.
all right, okay.
Mhm.
So now, the bar association
If you
is.
want to
Go ahead. Go
just let
ahead.
me try a little bit. If you just backpedal a bit. So, for
Yes.
example, say in the execution of a search warrant, right? The authorized officer goes and beats up somebody or acts unreasonably and destroys or damages equipment, that kind of thing, going outside of the scope of the authority, the reasonable scope of the authority, Section 45 will not protect you.
Uh-huh.
Mhm.
Okay. So the commissioners, obviously, in the legislation, it talks about the specific code of ethics there,
Mhm.
that they would be required to follow. And of course, if they get
Right.
out of
And
that,
so this
uh,
code of ethics now will come in the regulations.
within the regulations.
Mhm.
Okay, very well.
Yes.
Now, on the question of the regulations, what is the chronology? What is the timeline in respect of when those regulations are implemented, when those regulations come down? We know that the bill passes in the Senate this coming week. It goes to the Governor General's desk for signature. When do those regulations
The
come forth?
regulations, there wasn't a deadline per se on bringing the regulations into force, and the regulations would not need parliamentary approval. The
Mhm,
regulations will be settled and promulgated under the hand of the minister by order
mhm.
published in the Gazette.
It will be gazetted. Yes. Okay.
Yeah. So there
Very
isn't a
well.
time frame for that.
Okay. But I'm a subscriber to the Government Gazette, so I will
Mhm.
be looking out
You
for
will
those
get
regulations. Yes. Now, Madam Attorney General, the Bar Association is said to have sent a letter to your offices. Have you received the letter, and how will their concerns shape your government's approach to piloting the bill next week, when the bill comes before the upper house?
Yeah, so I have been in communication with the president of the bar from day one. And I requested the bar to send the concerns in writing. The president indicated that a dossier was being prepared that would be sent. And I look forward to receiving that. I'm sure it will offer much assistance. I've had a meeting with the president this week, earlier on this week. No, last week
Yes.
last week, Thursday or thereabout, right? I met with the president and a letter was handed to me, but the letter doesn't go further than what was already said in public. So, for example, the letter say, for example, the definition of authorized officer is too vague, but it
Mhm,
doesn't say why it's too vague. It doesn't say, well, we recommend this definition instead. And that's the general tone of the letter. It's basically one page comprising a number of one-liners. Um, Revisit this, review that. This is too wide, this is too narrow, but nothing more. So we would have to have some more engagement so that the bar can more clearly and in detail articulate to the Office of the Attorney General their concerns. And of course, these are my professional colleagues, and they know that what we can see from the AG's office, we can see the wisdom in the recommendations. We will consider them for amendments. Um, but I have not gotten substantial suggestions for amendments to the bill from the bar.
But
But we
Minister,
aren't.
wouldn't you concede that this is putting the cart before the horse? In other words, you brought the legislation to Parliament, and it was only after some citizens raised concerns that we now having consultations on the legislation. Although, notwithstanding, you said legislation was held in the past. Although the Bar Association said that they can't remember having any consultations on this
Well,
legislation in the past.
my brother,
Yes.
government is a continuum.
Uh huh.
Government is a continuum, meaning that government continues. The persons who administer the government may change from time to time, but government decisions, the decisions of the past government bind this current government because government continues. It is a continuum. So if I inherit a bill, if we inherit a bill that is at the stage where it just has to go to Parliament. The only thing that prevented it from Parliament is an intervening election. And the supporting information suggests that consultations took place. We have to take that in good faith and move forward if it is in the interest of the people and if it supports government policy to move forward, which is what we
Yeah,
did. So
I don't think that is in dispute. I don't
I'm
think that is
sorry.
in dispute.
Yeah, I'm sorry. So let me
Yeah.
finish. So having done that, and moving forward, and some of the people who felt they should be consulted, they come forward and they say, hey, we were not consulted, right? We are doing what we should have done. We've made some changes since up to the committee stage. The bill is scheduled to be in the Senate next week, but up to a few days ago, I sat with the president of the bar and we agreed that the bill can be amended as all other bills that pass in Parliament, as all other bills. Amendments may occur. So far, I have received no reason from the Bar Association, no dossier as promised, that would cause me to say to my cabinet colleagues, here we have these suggested amendments, let's do them before we go forward. There's
So
nothing prevented.
specific operational suggestions did not come forward from the bar.
No,
You said that they just made
no,
very open-ended suggestions, but
very,
not very clearly operationally definable suggestions that you can work with through the piloting process of the legislation.
you said it much better than I could have.
Okay, but now the prime minister also met with the Media Workers Association. Though the Media
Yes.
Workers Association need to be critiqued for their meeting with the prime minister, there's nothing wrong with meeting with the prime minister, but at least they should inform the general membership because the membership did not know about the meeting. And Mr. Gerard Joseph, I'm talking to you. They did not know about the meeting until it was published by the Government Information Service. The Media Workers Association says that they are still studying the bill. But have they put forward any suggestions?
I will share with you too, Dr. Bob, that I met
Yes.
with the Media Workers Association
Okay.
on Friday.
Hmm.
We had a sit down, and I think generally they did express the same concern, Section 33 in
Hmm.
particular, and we were able to discuss it. I was able to hopefully shed some light. And I did not get specific recommendations for amendment from the Media Workers Association at that meeting.
Okay.
They asked me, I think on some level they were relying on the bar to send me the promised dossier, and they asked
Hmm.
me whether I had gotten that, and I disclosed to them what I got, which was the letter I'm speaking to now. I actually pulled the letter up, showed them I had the letter in hand at the meeting,
Hmm.
and read from the letter for them some of
Hmm.
what was raised by the bar so far. And I think there was general agreement that some details need to be provided because with what I got, um, there wasn't enough to cause the AG's office to go ahead with any
Hmm.
further amendments. So
Very
once I
well.
that from my colleagues, and I did express to the Media Workers Association my willingness to meet with them again. They made some good suggestions, including that we should perhaps engage in further public education on the bill
Hmm.
and consultations, which I will take to heart and ensure that my colleagues and
Hmm.
I oblige.
Very well. Now,
Mhm.
final matter on the data protection bill, because I want to respect your time. It's almost lunchtime, or it's lunchtime now. But
Yes.
let us talk about the bill. The bill has language in respect of whistleblower protections.
Yes.
There currently is no whistleblower legislation in Grenada. When those regulations are advanced, would there be any gazetting around what the whistleblower function would look like? And when do you anticipate, as a government, that we would have some kind of whistleblower protection proposals for some data users that would be coming down the pike?
Yeah. So this bill, as you say, I think it will be the first bit of legislation. I could be subject to correction,
Mhm.
but thinking this is the first bit of legislation that would actually have some kind of protection for whistleblowers. So that is commendable. Um, in the regulations, as you quite correctly suspect, there would be some details as to who would be a whistleblower, what would be, considered exercising the whistleblower option,
Mhm.
and the like. So the regulations are still being worked on. They've not been completely fleshed out. As I said, this is an OECS draft. It's an
Yes.
OECS effort. And in terms of overall whistleblower legislation, I can't say that at present this is on the legislative agenda of government, but we have no difficulty if all of the relevant stakeholders think, I said all, I don't think I mean all, but if the relevant stakeholders think that it would be good and wise for us to consider such legislation, of course, we are here to represent the interests of the people. So we are willing to engage on the possibility of
As I was, yes,
legislation.
as I was with the previous administration, I vehemently and I still passionately advocate for there to be a Freedom of Information Act. I am now going to
Yes.
also add for there to be a Whistleblower Protection Act as legislated before Parliament, so that people who uh, reveal information that is in the public interest, um, that government might try to reveal, that these people are protected. I feel very strongly about that.
Right. So I can tell you in my engagement with the media workers on Friday, we did discuss the Freedom of Information Act. It is on the legislative agenda of government, and there is an old draft that we agreed we would work together to update with a view to taking to Parliament. They of course, they are to send to me a document, outlining some of the matters they would like to see as journalists included in an Freedom of Information Act. So that was something we discussed at length.
Okay, very well. Two final questions, Minister Joseph, as I have you here. The first one has to do, I'm not too sure if we have, I believe we currently have an acting labor commissioner, or has that role been made permanent for the acting labor commissioner?
No, the acting labor commissioner, she holds the substantive post of deputy labor commissioner.
Okay.
So she's in the role of acting labor commissioner now.
Where are we with exploring a position for filling that position, the position of a labor commissioner?
Oh, well, we would have to do the relevant advertising and interview of relevant interested parties.
Hmm.
So we are working on that. But settling down, and I must say the acting labor commissioner is settling quite nicely in the role.
So the concerns that you had, you said that the previous labor commissioner was not a good fit. That was a very open-ended way of describing it, in my opinion. But you said that that person was not a good fit. Would you say that those issues that the previous labor commissioner had, you're not seeing those issues with the person acting in this role now?
Well, very different individuals. So I would say the department is settling down nicely and
Okay.
getting on with our work.
So it was more of an interpersonal set of issues there, and not necessarily the quality of the performance of that person, was it?
You know what? Yeah, let the matter rest, and let me wish the former Labour Commissioner all the very best in her future endeavors. And
Mhm.
so I think it's time for us to move on.
Okay, very well.
Get
Okay,
back.
and finally, yes, finally, let us talk about minimum wage. I know that you have a minimum wage advisory committee. I believe that advisory committee, or at least some on that advisory committee, would also be dealing with the matter of pension reform, which is another urgent and pressing issue that must be dealt with uh, on the heels of the judgment that came down from the OECS Supreme Court last year. Now, I know that the committee has been constituted. Where are we with respect to recommendations that they have advanced? Have they advanced any recommendations as
Which
yet?
com-
And
which committee
that
are you referring
the
to?
minimum wage advisory committee, not the
Minimum
pension
wage.
committee,
Right.
the minimum wage.
Okay. So no, the minimum wages advisory committee, they are doing their work in three main stages,
Mm-hmm.
or phases. The first phase was what they've completed already, um, examining the state of things, the current minimum wage, the factors that were considered when that minimum wage order was promulgated in 2011. How circumstances have since changed, all of the relevant documents drawn locally, regionally, and internationally, including from the ILO, and so that they can get a sense of where the country is in terms of minimum wages. The
Mm-hmm.
next phase is what they're embarking on now, is the consultative phase, where they are meeting with all the relevant stakeholders, employers and employees alike in all the different sectors. They've done quite a few already. There's another one scheduled for Wednesday. Um, it's been advertised for the GBSS auditorium on Wednesday. There might be a change of venue there. So these now are
Mm-hmm.
the public consultations and direct consultations with stakeholders. For example, they've met with the Chamber of Commerce already, the Employers Federation, the Hotel and Tourism Association.
Mm-hmm.
I think they had some meetings with some of the agricultural persons involved in the agro processing sector. So we're going to be covering all sectors in these consultations
Mm-hmm.
and hearing from people their views on how this matter should be treated with, what the minimum wages should be like, what should be taken into account, whether new categories like media workers, people in the creative industry, people in ICT, whether these workers should also be included in the minimum wages order. And having gathered all that information after all the consultations complete, which we hope to complete by at least by the middle of May, um, they will then collate and analyze all information and make recommendations to me as Minister of Labour, which I will take to the cabinet.
Okay. All right. Okay. Senator, the Honorable Claudette Joseph, thank you so much for appearing on the Bubb Report this week. I felt that this was a very important conversation in fleshing out the data protection bill, because I believe you were able to answer some of the questions that I've had. And, it's something that we have been covering here on the Bubb Report, starting with Dr. Alexis, continuing with the president of the Bar Association, Mr. Sylvester, and continuing with yourself. And in the interest of balance, it was important that your voice as minister be heard on this issue as well. So thank you
Thank
for
you
your
very
appearance
much
on the
for
program.
having me. I look forward to coming back. And I say to all stakeholders, any law passed in the Parliament of Grenada can be amended or even repealed, so that if we proceed to Parliament on any legislation with which you have concerns, even if the law is already passed, feel free to reach out to me as the Attorney General, and we will take those concerns to heart and engage in any amendment that we need to. or even repeal of a legislation if it's required.
Senator Joseph, thank you for your appearance on the Bubb Report this week.